Commonwealth v. Gerardo Cruz.
Jeez.
Chief Justice Gantz, Associate Justices, good afternoon. My name is Mark Booker. I'm here for Gerardo Cruz, the appellant. Excuse me. I think that after the submission of the Commonwealth's brief, the legal principles don't seem to be in that much dispute between the parties, at least in reference to the constitutional principles that flow from Brady and from the state and federal progeny of Brady. And in that respect, I think that Mr. Cruz builds on bedrock. Under Brady, Mr. Cruz is entitled, among other things, to impeachment evidence. And that's precisely what he has sought here. He sought impeachment evidence.
Right, but he's entitled to material that's within the control of the government.
Yes.
I mean, or of the Commonwealth. In
Yes.
this instance. And in this instance, aren't these records that are more appropriately subpoenaed through Rule 17?
Well, it could be that some of the records that are sought and some of the records that are responsive could have been sought through Rule 17. That's true, Justice Cipher, yes. It's also true, though, that if the court looks at page 11 of the Commonwealth's brief and footnote 4, it appears that the Commonwealth has been able to take what Mr. Cruz described as the fairly simple step during the single justice hearing of asking Officer Murner about the information that was sought. That was, we thought, a minimal kind of first step, and they have done that. In addition to that,
It doesn't exist, right?
the answer was there's nothing derogatory in the IAD file. Yes, that's true. In addition to that, the Commonwealth makes clear that they've now asked the BPD legal advisor, who, as we pointed out in our brief, were present during every step of the way at the motion hearing in the BMC on October 12, 2017, and also a representative of BPD legal was present at the single justice hearing in November of 2017. And so they've now done that. And part of what that
While
illustrates...
they've been doing that, have you filed a Rule 17 motion?
No, I haven't, because at the time, I didn't, out of deference to the single justice and out of deference to this process. During the single justice hearing in November of 2017, one of the concerns that I heard the single justice articulate, which is reflected in the transcript, was the idea, the specter that the defendant might run back into the BMC court and seek some additional relief there by invoking Rule 17. And I didn't want to do anything that would suggest any hint that I was trying to circumvent the orderly process and the orderly airing of these particular issues that were here. Instead, what we did was, because we took issue with the manner in which the matter was disposed of in front of the single justices, we took an appeal from that, and we have submitted a brief supported by what we think is persuasive record evidence. And I think that now that the paper tracks have been completed, I think what the court can see, and what we can see readily, is that those simple steps that we described that were at least a minimal starting point, that is, that the Commonwealth could ask Officer Murner and ask perhaps his supervisors, including, not the least of which was Deputy Superintendent Ayala, who has an affidavit that Mr. Cruz, through his counsel, actually supplied to the Commonwealth, again, I reiterate, to facilitate their work, so that this could proceed in an orderly fashion, so that this could be done efficiently, so that there wouldn't be any gamesmanship. In other words, Mr. Cruz, through his counsel, was trying to be transparent about the proposition that we know that at the very least this is out there, and this invites serious questions, as we put it during the motion hearing, about Officer Murner's credibility, about the way that he's handled informants, about his submission of search warrant applications and the affidavits attendant to those applications, and certainly we're entitled to explore that.
So once the Commonwealth asks and gets an answer,
Yes.
what would the next step be?
Well, in our view, the discovery request as drafted and as allowed as drafted was proper. And so that step that the Commonwealth took, I regard as a necessary step, but I don't regard that as sufficient. In other words, it was never our position that as long as the Commonwealth asks Officer Murner for this information and receives a response and then conveys that response to us, that would end the matter and we'd be satisfied.
This is my concern with that.
Yes, Justice Lowy.
Perhaps a better question for the Commonwealth, but it's great that the Commonwealth asked about this. They decided to ask about this. But I think, analogizing the Commonwealth versus Beale, they didn't have to ask. And therefore, doesn't that show that it's not that you might not get this information, it might be really important information, but that you have to make a lampron showing to get it, and it matters what the process is.
Well, I respectfully disagree. I think under Rule 14, and the reporter's notes to Rule 14, and even the Commonwealth's own presumptive discovery policy, which was appended to the Commonwealth's appendix at page 73, Commonwealth Appendix 73, is a written discovery policy of the Suffolk County District Attorney's Office. Even in that policy, the Commonwealth acknowledges that impeachment evidence under Giglio and those line of cases is something that has to be turned over. And so this
If they have it, if it's in the possession, custody, or control of the Commonwealth. I think it's great they asked. It's just that I don't think they have to if it's not in their possession, custody, or control, and you have a right, if it really rises to that level on the 4 prongs of Lampron, to have it. So, I mean, the process matters here in this case and in general.
Yes. And so in this case, we respectfully contend that they did have it. They did have it, at least a portion of it, because Officer Murner is without question, no one has ever disputed that he's a member of the prosecution team for purposes of Rule 14. He is. He's the chief witness against Mr. Cruz in this case. So he's a member of the prosecution team. And at the very least, he had knowledge and perhaps documents that were responsive to the information that was sought. And rather than turning that over promptly,
Well, what if it were a witness? What if it were a non-police witness? Wouldn't the same reasoning apply?
well, if it's a non-police witness who's a member of the prosecution team, for example, if it's a witness along the lines of the witness who was at issue in Commonwealth versus Martin, the DNA analyst, if it's a witness such as the criminalist who was at issue in a recent case this court decided, Commonwealth versus Gerald Sullivan, their post-trial, post-verdict, the Commonwealth produced information to the defendant that indicated in substance that the criminalist who had testified at the trial, in fact, had failed several proficiency
Medical
exams.
examiner's office? Medical examiner's office?
Medical examiner's office, I believe, would be covered by Rule 14. Certainly someone who's performing laboratory testing for the Commonwealth, as the cases going back to at least Martin recognized, they're members of the prosecution team.
And if they were, would you be allowed to get their, ask the prosecution to ask them if they had received therapy or counseling?
Well, I suppose that would tread into what are classically considered pretty sensitive, normally confidential areas. I would say that in the Farrak scandal, the Sonia Farrak scandal, I believe that counseling records ended up becoming pretty important in that case. And the conduct of Ms. Farrak, Ms. Dukin, and some others, but those two notorious cases come to mind, certainly has highlighted the fact that an employee's conduct, an employee who is a member of the prosecution team, their conduct at work is certainly subject to discovery under Rule 14.
Have we ever held that a police officer's employment file is Rule 14 material?
I haven't seen that, but what I did see recently and read with real interest before I came here was the recent case, Committee for Public Counsel Services against Attorney General. And I believe Your Honor might have authored that.
I'm familiar with it.
Right. So, and in that case, I note that the court indicated that it wanted the Standing Advisory Committee to consider a Brady checklist and look into that. And I think that part of what that reflects is that increasingly around this country and in this Commonwealth, the courts are becoming.
But I guess
Yes.
what Justices Lowy and Cipher are asking you, if it's not Rule 14 material, it's available under Rule 17, right, with the appropriate procedures under
Yes.
under Lampron.
Yes, and in this particular instance,
And if the government, like in Farrak and in the Sullivan case we decided recently, if the government knows of this information, it becomes Giglio or exculpatory Brady material, they have to give it to you.
right, and so we made them know. I furnished the Ayala affidavit and said, we're interested in this, please tell us about this, and we did that, so.
Well, wouldn't that give you the grounds for your Rule 17 if you knew about it?
It would, and here's where I understand the Commonwealth's point that they make in the brief about the way in which the motion hearing was conducted in the BMC. In the BMC, the transcript, I think, spans something like 50-plus pages. The hearing was approximately 1 hour long, a considerable amount of the court's time in a busy trial court. And during the course of that hearing, my understanding was that the court allowed the BPD to intervene in the case over the defendant's objection, and then I was at great pains to want to make clear on the record that it seemed to me that the court was in fact conducting both a Rule 14 related hearing and a Rule 17 at the same time, because you had the third party, the Boston Police Department, there in the room, represented by able counsel, and we were able, all the parties and counsel, to air all of the issues. And the court spent a considerable amount of time on that. And it was my understanding that although certain formalities might not have been observed.
Well, I guess that's important, though. I think the lessons we learned from Lampron and its progeny are that it's important to go through the Lampron steps, to drive all the protocols and not short-circuit them, because third parties have rights, the defendant has a right to discovery as well, and we need to make sure that we follow these steps. So
Yes.
I don't think a truncated Lampron/Rule 14 hearing is the way to go.
And also, the way it's not too different from what Justice Graziano was saying, but the fact that there was an expansive discussion doesn't mean you don't need the affidavit and identify and go right through all the four steps. This is not about what you're entitled to. It's about how you're entitled to get it.
Yes. It wasn't denominated as an affidavit in support of a Rule 17 motion, obviously, but in our record appendix at pages 61 through 64, you'll find my affidavit that was filed in support of the motion that was styled as a Rule 14 motion. And it contains, I think, fairly detailed averments that span those 3 pages and consist of 21 numbered paragraphs that kind of rehearse a lot of the substance of some of the affidavits that are at issue, the 4 that are set forth in the factual component of our brief.
Okay, thank you, sir.
Thank you very much.
Mr. Zanini, thank you for your patience.
Thank you, Mr. Chief Justice. May it please the court, John Zanini for the Commonwealth. With me today is Assistant District Attorney Alexa Ray Wright, who handled the matter in front of Judge Byrne in the BMC. Also Benjamin Gilbert, who's a law student who assisted on the brief. So very quickly, the transcript of the BMC proceeding has been made part of the record. The pages of that proceeding that actually involve this particular issue span from page 11 to page 15. That is it. All of the rest of the proceeding is about confidential informant and disclosure of confidential informant information. The pages that my brother just referenced regarding his affidavit and what's in his affidavit are about the 2 Cruz brothers' affidavit. They have nothing to do with the affidavit where the dispute between Myrner and Ayala arises, which he produced only at that hearing and suddenly came up with it and said, well, here's the other thing that I'm interested that supports request number 2. So that was just sprung on the Commonwealth. Nonetheless, the fundamental position of Judge Byrne was that personnel files and IAD files, if they have exculpatory information, must be reviewed and produced by the prosecutor. That was her position. And notwithstanding the interjection of the Boston Police Department attorney who was there, who said, first, personnel files are not in the care, custody, and control of the government, the prosecutor, and second, IAD files are not in the care, custody, and control of the prosecutor, and she specifically cited Wanis to Judge Byrne. We then filed a motion to reconsider, specifically citing Wanis. So this expansive discovery request and the order of the judge was for the prosecutor, at her peril, apparently the judge sensing a constitutional duty, an ethical duty, and now a court order. She had to go personally look at the personnel files and the IAD files. We can't do that. We don't have access to them. So Justice Kafka, as the single justice, vacated this order to the extent it was entered under Rule 14. I would suggest the court should affirm his ruling as his ruling is entirely compliant with the Wanis case, which this court decided 20 years ago. I argued that case, and in that case, I actually argued that the prosecutor should be allowed to go look in all those files in order to produce exculpatory information. BPD appeared, intervened, was allowed by this court to intervene, and argued absolutely not, those are our files, not yours. And this court said, right, those are the police department files, those are not the prosecutor files.
And I assume you're not asking us to revisit that.
I am not asking you to revisit that today. If you want to revisit it, it's going to be a lot of work for a lot of people. Amicus briefs, and with 20,000 cases a year, the amount of work that will take will.
So in practice, when this requests come, you say the appropriate course is to pursue a motion under Rule 17?
Yes.
If the prosecutor were to obtain information, regardless of whether it has to do with a police officer or, in the case of Sullivan, somebody as a criminalist, you agree that there, depending on the nature of the information, there could be an obligation under Giglio to furnish that as impeachment information?
Yes, depending on the nature of the information, which then relates to our Rule 608, which is, or our Guideline 608, which is distinctly different than the federal Rule of Evidence 608, because our general presumption is that other misconduct in other cases, or even other lies, except for Bohannon, is simply irrelevant and inadmissible. So depending on the nature of the information, it may or may not be subject to disclosure. But none of this information was at our care, custody, or control. It's all Rule 17.
It appears that the officer's already been asked, quote, whether he was ever disciplined, admonished, investigated, or reprimanded by the Boston Police Department based upon his work on search warrants, applications, or confidential informants, unquote, and he has responded in the negative. Are you saying that that should not have been asked?
Well, so that's an interesting question, which I think is not squarely presented by the judge's order and the single justice ruling. And in this case, the request actually went beyond that and asked about not just search warrants and affidavits and confidential informants, but or other civilians in connection with his work as a police officer. So this was essentially the request was, have you ever been investigated? Does BPD ever investigate you in relation to any of your work in connection with any civilians? So this is the broadest possible discovery request. In any event, I did ask Eric Murner that question about the affidavits, the search warrants, the confidential informants. There has been no investigation, there has been no admonishment, no discipline, no reprimand, because as I explained, Norma Ayala, who subsequently retired, what was in the file that she looked at did not contain all of the history of that particular person, is the information we have now. And so she made a simple mistake. So you have two affidavits that appear to be in conflict, but it's based on a simple mistake. It's an imperfect world, and the pieces of paper hadn't made it from wherever they were into that central file she looked at, is my understanding.
Okay.
So I'm not sure if we have a duty to ask every single officer whether they've ever been investigated by internal affairs, which is different than anti-corruption in the Boston Police Department. The anti-corruption division investigates criminal conduct or alleged criminal conduct, and we're sometimes aware of that because we would get involved. The IAD is more of a, you broke a rule, we're investigating whether you broke a rule, and breaking a rule typically is not going to be admissible under 608 in a criminal case to impeach anyone.
But the other might be.
The anti-corruption, if there's actually a crime,
Yeah.
that might be if it results in a conviction, because then what you have is an impeachment by conviction. If it doesn't result in a conviction and it's unrelated to the case being prosecuted, then it's not typically admissible. And the cases from this court on that are Ellis and Campidi and the Waters case. One of those is an appeals court case. I can't remember which.
But nonetheless, there's absolutely nothing wrong, obviously, with asking, but whether or not there's a duty to ask is not part of this case.
Correct. It's not at issue at all in this case with respect to Justice Kafker's order or the underlying order from Judge Byrne. Unless the court has other questions, I would rest on the brief.
All right, thank you.
Thank you.
All right. Hear ye, hear ye, hear ye. All persons having anything further to do before